the dean, the faculty of this great university, and above all, my beloved young students of the various institutions which you have developed here. It is these youngsters who, at my age of 90, keep me young. I'm a follower of the teaching of King Solomon, who, once I advised my Prime Minister, has left a prescription for eternal youth. Don't misunderstand. The prescription that he has left is that the older you get, the younger should be your company. I'm sorry I didn't mention the great audience present here, those invited guests who are all very busy people in life, who are very great intellectuals, including, of course, a judge of the High Court. I hope there are many more judges present here. And you have the great qualification of an audience, and that is the capacity to suffer for long. You have already heard 7 speeches, and mine is the 8th. So far as I am concerned, I feel like the 8th husband of Elizabeth Taylor. On the day of the wedding, he confided to a friend that I know what I am supposed to do, but I don't know how to make it interesting. I don't share the attitude of that 8th husband of Elizabeth Taylor. I am very grateful to the previous 7 husbands who have all spoken before me. They have made my task so much easier. I had about 15 pages of my notes for my speech, and before I entered this hall, I told them that please give me a little more time. Most of them promised. Only Soli Sorabjee has kept his promise. But ladies and gentlemen, I am very grateful to them because there is nothing from which I differ. I have no conflict of interest with them. And it's very funny that all the 7 are the friends of the 8th husband. They have made it very easy for me to deal with Elizabeth Taylor. First of all, let me be clear what exactly is the meaning of independence of a judge. A point which Parasaran touched, a point which even my friend Soli touched. Ladies and gentlemen, first is the independence of the judiciary in common parlance from the influence and control of the executive. That is important enough. But once again, please understand that in the pre-1993 constitutional position in India, when the executive had the veto power in the matter of judicial appointments, we still produced some very great judges. Judge like Mr. Justice Fazal Ali, Justice Vivian Bose, many others. They were great judges, and they were the products of the very system which we ultimately came to hate. It's not the fault all the time of a system. The fault is of those who man a particular system. if those who man a particular system are not independent, are ill-minded persons, or they are intellectual cowards, whatever system you give to them, they will produce evil results and will find nothing commendable in their career. It is true that even the worst system where the executive had primacy and the veto power, great judges did exist. But later on, as human character declined, because men like Sardar Vallabhbhai Patel, great distinguished Home Minister of India, Govind Vallabh Pant, another great Home Minister of India, when people like this no longer existed in India, and some intellectual and moral pygmies started occupying those great offices, the decline of the system started, and we attribute it not to the decline of character, but we attribute it to the decline of the system. So, ladies and gentlemen, even the worst system that existed under the original Constitution of India prior to 1993, we could produce good judges of whom posterity has reason to be proud. But I said that ultimately character started declining, and character started declining so much that today the politician has become the butt of jokes. Politician today is at the lowest watermark of his social acceptance and respectability. I have always been sharing the latest joke about politicians with my audience, and I don't wish to make an exception in your case. The latest joke is that if one politician falls into the river and drowns, it will be a simple case of pollution. But if all the politicians fall into the river and die at the same time, it will be the solution. Even the lawyer's profession, to which I belong, has suffered a terrible decline in the matter of social acceptance. Again, huge volumes of joke books have been produced, and those of you who are interested in knowing the best jokes about lawyers must read a book called Professor Gallanter's book, with an old friend of mine who has produced a huge book like this. The title of the book is The Profession Lowers the Bar. And ladies and gentlemen, one of the jokes in that great book about lawyers is that the pharmaceutical laboratories in the United States have decided that in their experiments in their laboratories, which they make about scientific matters and so on, they will use lawyers instead of rats. So when I heard it, I thought that there is some contribution scientists, lawyers have to make to the growth of science. I didn't feel so bad. But the pharmaceutical laboratories then gave 3 reasons why they had arrived at this decision. Reason number 1, that lawyers are more numerous than rats. Reason number 2, that it's difficult to fall in love with lawyers, as occasionally we do fall in love with our rats. And the third was a more humiliating reason, that there are certain things which lawyers do which even rats will not do. Ladies and gentlemen, I must plead guilty to the charge that I belong to both these professions. But fortunately, there is a saving grace in my life, that I have a third and a fourth profession. I have finished legal practice for 71 years. But my tenure as a teacher of law is longer by 1 year. I am still finishing the 73rd year of my law teaching. You might be surprised to know how this can be possible. Ladies and gentlemen, I qualified as a lawyer at the age of 17. When I applied they suddenly confronted me with a rule which required that you should be 21 before you can be enrolled. So the first case which I argued in my career was my own case. I went to the Chief Justice of Sindh. I am talking of the province of Sindh, which is no longer with us, it's now a part of Pakistan. I argued my own case and I told him, I said, sir, when my parents sent me to the law school, if they had been aware of this rule that I will not be able to support them for the next 3-4 years, they would never have made me a lawyer. How can you apply this law with retrospective effect when it did not exist when I joined the law college? It was passed only when I was already in the law college. The Chief Justice says, young man, you have an excellent point to make. I won't give you an immediate relief, but I am giving some good advice to the Bar Council. So he advised the Bar Council to make an exception in the rules, that in suitable cases you will make an exception. Then he says, young man, now you apply under that exception. I did. I had no difficulty. I had a unanimous resolution of the Bar Council, but even they found one defect still. They said at the age of 17 you are a minor. Your contracts are void. So how can you be a lawyer? So they said, we will enroll you the moment you complete 18 years of age. Ladies and gentlemen, between 17 first of all, you must understand that judicial independence is not merely independence from the executive. It is important that it should exist, because no litigant can have any part to play, big or small, in the selection of the judge which will decide the litigation to which he is a party. Today, ladies and gentlemen, particularly after India became not merely a democracy but a democratic republic, the difference between a democracy and a democratic republic is very vital. In a democracy, those of you who young students, I hope you are still reading Dassey's Law and Custom of the Constitution. In a democracy, the parliament is supreme. The majority in parliament can do anything. No court has the power to challenge what the parliament. As Professor Dassey says, that the Parliament of England can turn a man into a woman and woman into a man, but no parliament would have the right to, no judiciary would have the power to say that this law is ultra-virus. It's ultra-virus what? They have no written constitution, except now when they have become parties to the Rome Treaty. So ladies and gentlemen, a democratic republic is a vitally different institution from a mere democracy, and our constitution calls India a democratic republic, and the constitution makers were so very clear about the use of proper language that they will never use two words instead of one, and therefore when they called us a democratic republic, they had a great purpose to serve, and that purpose was that sovereignty, unlike in a democracy, does not vest in the majority of the elected representatives of the people, but it vests in every individual citizen. There are certain things which even a unanimous majority in both houses of parliament cannot do. For example, they cannot say that Mr. Jethmalani is such a maverick and an inconvenient maverick that he shall not be allowed to make any speech anywhere. The law will be declared ultra-virus. It will be declared ultra-virus by the judges. And if at all, in a democratic republic, ladies and gentlemen, the sovereignty in a sense resides in the judges of the realm. And if sovereignty is to reside in the judges of the realm, it is obvious that the judges must have independence, because in a republic, the greatest and the most prolific litigant is the government of the day, the state. The state also includes all its agencies, and it also includes the big army of bureaucrats who are the face of the Republic of India so far as the common citizen is concerned. So if you have the misfortune of becoming a litigant, either because you are compelled to initiate it or because you have been called into court by somebody else who has already instituted a litigation, the victim of every litigation is entitled to one great requirement, that he should not have the slightest suspicion about the complete, unqualified impartiality of the judges who decide his dispute. And this by itself disqualifies the executive from having any control over the appointment process so far as the superior judiciary is concerned. And ladies and gentlemen, to my mind, even membership of a political party should be considered a disqualification, unless, of course, some person, in view of his ultimately becoming a judge, at least about 10 years before his becoming a judge, he has given up his association with the working political party. Otherwise, it should be a disqualification. Because political parties are today ranged in opposite sides of the litigation, and we do not want one person to complain that the other fellow is connected with the party to which I don't belong. After all, judges recuse themselves if one litigant before them is a member of the same club to which the judge belongs. How can you have judges sitting there who are active members of a political party only the day before to decide disputes about members of another political party? So, ladies and gentlemen, that the executive has to have no voice in the appointment of judges is an inevitable, is an inexorable, it is an unavoidable conclusion from the terms of the Constitution, because we are a republic, and in the republic the citizen is usually ranged against the state and its instrumentalities. Now that is one. But ladies and gentlemen, as I said, there is something like that. You may be independent, but you may have other problems. And as one of my previous Elizabeth Taylor's husband said, that you should also be independent of what? You should be independent of the frailties of your own character, your own greed of money, your own greed of promotion and power, your cupidity, your other defects of character and conscience. And all these are characteristics from which a judge has got to be independent before he can call himself independent. Now the 1993 decision in the famous Advocates on Record case, which overturned the 1981 decision, the Gupta's case, is a great landmark in the history of the judiciary. I had the honor of appearing for the Advocates Association in that matter. And ladies and gentlemen, the argument that I made before the judges was very simple. That the Keshwanand Bharati case, decided long ago, laid down the proposition that there are certain parts of the Constitution of India which constitute its core, and that core or any part of that core cannot be abrogated or even diluted by even a constitutional amendment. In other words, even if you have a two-thirds majority in both houses of parliament, that core cannot be touched or diluted or abrogated. So we argued in 1993 when I appeared in the Supreme Court before the 9-judge bench. What did I tell them? I told them that please look at Article 50 of the Constitution of India. Article 50 of the Constitution of India says that the state shall strive to keep the judiciary and the executive separate. And I argued before them that this does not mean that judges and politicians should not meet in a club. This does not mean that they should not reside in the same bungalow, that they should not reside in the same locality, or that they should be compelled to reside in different cities. It does not mean physical separation. What it means is that you have no right to select the ministers or the executive. They have likewise the obligation not to interfere with your appointment. And I said that Article 50 of the Constitution of India is a part of the core of India's Constitution, and therefore you must construe the word consultation in the context of the core of the India's Constitution. The core is that the executive should have no hand in the appointment of our judges. And judges not merely of the superior court, but judges of any rank, the lowest, this principle applies to all. And ladies and gentlemen, it is this argument which has been basically the fulcrum, the foundation of the 1993 judgment, in which they said that we will have to construe the word consultation as concurrence, because unless you do it, there will always be interference of the one with the other, and that will be trespassing into the field of the other, and it will be a trespass in the matter of the core of the Constitution. Now, ladies and gentlemen, let us assume that the 1993 judgments, modified to some extent by the 1998 judgment, produced the collegium system. Now look, the collegium system's defects have been pointed out. I don't disagree with any criticism of the collegium system, but ladies and gentlemen, there is some difference of emphasis. The collegium system was designed by a judicial decision to become a part of the core of India's constitution. The first criticism is that this is not legislation, this is judicial legislation. But ladies and gentlemen, the article of the Constitution says that a law declared by the Supreme Court in any judgment shall be binding on all authorities. Therefore, whenever you interpret the law, performing the role of an interpreter of a law, which is a part of the essential role of the judge, that he interprets the law all the time, if the court interpreted in the context of Article 50 that consultation means concurrence, then that has now become the core of India's constitution, and you cannot abrogate or dilute that core which has been created by a judgment of the Supreme Court in 1993, modified to some extent by 1998. But ladies and gentlemen, that core is possibly terribly exempt in every sense, even from a constitutional amendment. And that is what I argued before the Parliament on that day in the Rajya Sabha, when I had the distinction and the honor of being only one person in the whole House who sat there and spoke for 45 minutes, and I explained to the Parliament what was happening. I must record on this occasion that the leader of the opposition made a speech. Of course, ladies and gentlemen, he is not my leader because I am still an expelled member of the BJP. So that expulsion makes me completely free of all restraint. So, ladies and gentlemen, the speech of the leader of the opposition, who got up and spoke for nearly 45 minutes, from the first word to the last, could have been a part of the law minister's speech in support of this constitutional fraud. And ladies and gentlemen, Mr. Parasaran will tell you that he was present. He told you already that Ram was the only person who spoke for the opposition to this bill. I spoke for opposition against the bill because I said that the bill is a fraud. What have you done? I have no objection to your saying that you will, under which you said in Article 124A, newly added by the Constitution Amendment Bill, that there shall be a judicial appointment commission, they call it. They don't call it the National Judicial Commission. With the manifestos of many political parties, including the BJP, the BJP manifesto has talked about the creation of a National Judicial Commission. So at least I am not offending the BJP when I support the National Judicial Commission or the National Judicial Appointment Commission. But, ladies and gentlemen, having said that there will be a judicial appointment commission in Article 124A, which they have introduced, the Constitution, the powers and the structure was not left to the Constitution, but was left to an accompanying bill which can be repealed tomorrow, by having one member's majority in both houses of parliament, you can exercise that majority and take away that power. You can say tomorrow, for example, I am saying that Mr. Kapil Sibal, who piloted this bill, is a very honorable man. He will not do it. And when he came to know that I was the sole opponent to his bill, and he's a great friend of mine, he has been a friend of mine at the bar, and even though he's a member of the Congress ministry, I still respect this man. I am keeping a great watch over this law ministry and how it works. And I have some praise for that man. There are honorable ministers in the cabinet. I don't say no. But when he realized that even Ram is opposing his friend, then he walked up to me in the house and he says, Ram, how are you opposing my bill? Because he had worked out a wonderful agreement with every section of the Rajya Sabha. So I told him, I said, Kapil, my conscience does not permit me to collaborate with you in this dark deed that you are performing. And I said, please tell me, you answer my question. You are now saying this is the constitution of the Judicial Appointment Commission. Tomorrow, what prevents you from repealing this and passing another bill in which you will say that the Minister of Law shall be the sole appointing authority for Supreme Court judges? Is there anything to prevent you? He said, Ram, but do you think we will do it? I said, you did worse things during the emergency. What the hell are you talking about? You destroyed a living constitution during the emergency. You are capable of doing that all over again. And please, don't tell me that you will not be able to do this all over again. And ladies and gentlemen, I did want to read to you that in my speech, I did say, and I am quoting the exact words to you, I have great respect and affection for my friend Kapil Sibal, the Honorable Minister of Law and Justice. I do not wish to expand this, lest it may embarrass him with his colleagues. That is, Ram Jethmalani's friend must be a great disqualification in the Congress party. I would not easily oppose bills introduced by him unless my understanding of the Constitution and my conscience urge me to revolt against acquiescing in such diabolical pieces of legislation. Both my intellect and conscience tell me that these bills will set up an evil precedent of Parliament, deliberately damaging a basic feature of the Constitution, making liberty tenuous and gravely attenuated, weakening the judiciary, rendering human rights vulnerable, and exposing democracy to the threat of extinction. So, ladies and gentlemen, after hearing my speech, at least some members of the BJP party realize that what Ram is saying is true, though we have expelled him. They at least staged the walkout, but the walkout was not enough to prevent the bill getting a sufficient majority, and it went through the Rajya Sabha. But I have always wondered, ladies and gentlemen, that how does India survive with so much of corruption and with so many corrupt rulers? I have a feeling maybe that it is wishful thinking. I personally think that there is somebody in the other world who is looking after us. Kuch to ho raha. There is something happening in the other world. And today I believe that we are now seeing the coming of a new dawn when the people of India have begun to realize what is the danger which we are facing today to the democratic system and to the democracy and the independence of judiciary, without which the republic is a sham. It's a joke, if you ask me. So, ladies and gentlemen, today, please now talk only of the character of judges, which has nothing to do with merely being independent from the influence of the executive. What I want is that the judge should have his own free conscience and free intellect. How do you get it? In other words, I am talking of character. And when you have fixed this subject today, will the Judicial Commission create more independent judges, yes, it will create independent judges in one sense. They will be independent of the executive power in the matter of appointment. They need not become employees of the government, but they may still be employees of their own bad character. Now what do you do, ladies and gentlemen? How do you create? Proposition number 1, character cannot be produced by legislation of any kind. You cannot legislate good character because the whole penal code exists for creating good character. But you see what is happening every day. After that rape which took place in December last, the number of rapes seems to have increased. And that is exactly what is happening to the corruption. Every day there is some new racket discovered, and finally the CBI director, who is a slight improvement on the previous models, I heard slight, but he is just certainly a distinct improvement upon the previous predecessors of his. He registered the latest first information report in which it cannot be denied that the Prime Minister is a party to the decision. Once again, ladies and gentlemen, the Prime Minister of India, though we belong to two different political, what should I say, I won't say that I now belong to any party, but ladies and gentlemen, that we do belong to two different systems of political thought, and I am very happy that at least the Prime Minister has had the moral courage to say that I do not mind the CBI having registered this FIR, and I am quite prepared to submit myself to interrogation by the CBI. This is evidence of good character of the Prime Minister to some extent. To some extent again, because I don't wish to prejudice the action of the CBI either by a certificate of a person who has been his friend in the previous regime. In the previous regime, he had the distinction of bringing India and America together. The Americans agreed ultimately to become our brokers and go around the whole world. Those 45 suppliers who are in a position to provide nuclear material to us, the President of the United States undertook that I will persuade all the 45 to see that you get nuclear material. And I thought that he is a great, great friend of India who has got the mighty Americans, and I am afraid that even President Obama today does not fulfill the promise which his predecessor has made. Now that is big politics. India has always been happier with the Republican Party in power rather than the Democratic Party in power. But that's apart. Some of you who are interested in foreign affairs should please consider this. And ladies and gentlemen, character is the product of nature plus nurture. Nature, you get your character mainly through your mother's milk. What you imbibe during the period in which you are in the womb of your mother, some characteristics are born into you. They exist when you are born, and ultimately how your family nurtures you and how the great teachers and professors in our universities take care of your character. That is where character is made. And that is why, ladies and gentlemen, I am all for education, because the education process today is totally vitiated in this country. The education in this country gives you knowledge but no wisdom. It gives you a thirst for power, but it gives you no sense of social responsibility to the people. It produces cleverness, but it does not produce conscience. That is the failure of our educational system. And ultimately, ladies and gentlemen, the value of a civilization depends upon the manner in which you treat your teachers and professors. Our teachers and professors lead a life usually of honorable poverty. We do not exalt them to the pedestal to which they are entitled by virtue of being in charge of the minds of the young. And I am very glad that this university is producing in its short tenure a great reputation for itself, and you have a great faculty. And ladies and gentlemen, please keep up the educational system. There is no other method of producing the character of independence of the judges from their own self. And lastly, ladies and gentlemen, I am grateful that you called me here, because this is the kind of work which I enjoy. I enjoy it more than my profession. I enjoy it more than, of course, my parliamentary career of a politician. I even enjoy it more than my third characteristic, which I had pointed out, the teacher of law, but I have also a fourth. Knowing the pitiable state of the press in this country, I have started my own newspaper, the Sunday Guardian. I am the chairman of the board. I claim that that is the one paper which writes nothing but the truth, the whole truth, and nothing but the truth. It is a weekly. I started it in Delhi. We had another center in Chandigarh, and only about a fortnight back we have started another center in Bombay now, and soon enough I will come to Chennai. I am grateful to you that you have asked me to come here and speak to the young minds, particularly in this great intellectual audience, and I am equally grateful to you for that great gift that you have given me. But I must confess to you that I have examined my family pedigree up to the 7th degree of the common ancestor, and I find that there is not one musician. I respectfully suggest that if next time you have to give me an instrument, please give me some young musician, and thank you.